Hello everyone, my name is Curtis. Today I want to have a conversation about the lawsuit that Shamea Morton filed against Pretty Faces Atlanta. Before I get started, I do want to give a disclaimer. So I am not a legal expert, I am not a medical professional, nor am I giving any advice. I am just providing information about what allegedly happened to Shamea. Alright, so now that we got that out of the way, let's get started. So Shamea Morton, who is a cast member on the Real Housewives of Atlanta, has filed a medical malpractice lawsuit against Pretty Faces Atlanta, which appears to be located at 4600 West Village Place, Suite 3005 in Smyrna, Georgia, which is in Cobb County. Shamea claims that she has second-degree burns, blistering, and permanent scars after receiving a chemical peel from Pretty Faces Atlanta. And the reason why she feels like this is because when it comes to the chemical peel, apparently it was too strong for her skin because she has a condition called tinea versicolor. Hopefully I said that correctly, but it's a fungal skin infection causing discolored patches on the trunk, which is the torso, neck and arms often appearing flaky and more obvious after sun exposure. And then also she says that the procedure was completed by a third-party provider who she claims did not take her pain seriously. Which is something that you hear a lot, unfortunately. When it comes to medical professionals, it seems like, or it appears at least, that when it comes to black women, they do not take their pain seriously. It's like a black woman could say, you know what, I'm in pain, I'm hurting, can you give me some type of medication, or can you just simply stop? And it's like, oh no, you can handle it, like you're strong, it can't be that bad. Come on now, we work with plenty of people, they didn't have this type of experience, they didn't complain about this pain, you're just making an excuse. And I don't think that's right at all. Now, I do want to talk to you all about the statute of limitations and the statute of repose in the state of Georgia when it comes to medical malpractice. And I am going to read this directly from my notes, okay? And before I begin, I just want to point out one more time, I am not a medical professional, I am not a legal expert, nor am I giving advice. I'm just reading out the information, okay? This information is coming from Georgia Code 9-2-71. Except as otherwise provided in this article, an action for medical malpractice shall be brought within 2 years after the date on which an injury or death arising from a negligent or wrongful act or omission occurred. Notwithstanding subsection A of this code section, in no event may an action for medical malpractice be brought more than 5 years after the date on which the negligent or wrongful act or omission occurred. Subsection A of this code section is intended to create a 2-year statute of limitations. Subsection B of this code section is intended to create a 5-year statute of ultimate repose and abrogation. And it appears that you have to get a pre-suit affidavit before you can even file a medical malpractice lawsuit in the state of Georgia. So once again, I'm not a legal expert, so I did go onto a law firm's website, and the law firm is for Adam, Jordan, and Harrington. And I'm going to read what is on their website word for word because I don't want no problems, all right? Alright, so it says, in Georgia, a medical malpractice claim cannot even reach the courtroom unless it is filed with a supporting affidavit from a medical expert. The expert must be in the same or similar field as the defendant and must actively practice or teach. The affidavit must name at least one specific negligent act and explain how it violates the relevant standard of care. General dissatisfaction or poor outcome isn't enough. It must be clearly tied to a breach in protocol or skill. The affidavit filters out unsustainable claims. It must include precise language and medical grounding. If omitted or flawed, the case is dismissed immediately. Because of its weight, the affidavit is often the most scrutinized document in the case. Lawyers must spend time preparing it with expert input and legal clarity. A properly prepared affidavit turns a complaint into a case. Without it, the claim never enters the system. So let's go back really quickly. So it says, if omitted or flawed, the case is dismissed immediately. So this document is pretty important. But it does appear that you also have to prove some other things. So once again, I'm not a legal professional. So I did go on to the law office of Jason R. Schultz's website, and it says the following. You do have to prove that you had a professional relationship with the healthcare provider, establishing their duty to treat you with accepted medical standards. You have to prove that the provider failed to meet the expected standard of care, meaning that they weren't as skilled or competent as a similar professional would have been. You have to prove that the provider's breach directly caused your specific injury. And you have to prove that you suffered actual harm, such as physical pain, significant medical bills, disability, or loss of income. So as you all can see, filing a medical malpractice lawsuit in the state of Georgia is not that easy. I do hope that Shamea is successful in her suit if what she is saying is true. But what do you all think? Do you think that she has a case? Let me know in the comments. I want to thank you all so much for watching. I really do appreciate it. If you could, please like, comment, share, and subscribe. That would be great. I do hope you all have a great rest of your day. Take care. Bye.